Good morning. Welcome to today's meeting of the Public Service Commission. This commission meeting will come to order. I'd like to begin by saying how proud I am of the PSC staff as we've begun to repopulate the offices in downtown Baltimore. Earlier this week on Monday, our transportation division went back to full strength in our offices, and hopefully with a steady and safe approach, we'll begin to have other members of the PSC team back in the offices in the coming weeks and months. We're looking forward to that and having the team back together. I'd also like to acknowledge and congratulate my good friend Jamal Hudson, who was appointed yesterday by the Virginia governor to be the newest member of the Virginia State Corporation Commission. Jamal and I were colleagues at FERC and both alumni of the U.S. House of Representatives. I think he will make a fine judge at the Virginia Commission, and I look forward to seeing him in some future MAC group meetings. So congratulations, Jamal. With that, I'd like to recognize the gentlelady from Pasadena, Commissioner Herman.
Thank you, Mr. Chairman. I'd like to make a brief statement about the passing of a good friend of mine and a former chief hearing examiner at the commission. Paul Harrington passed away last week. Paul was the chief hearing examiner at the commission from 1985 to 1991. He also worked at Washington Gas and Pepco during his career. Paul was incredibly smart. He had an amazing memory for cases and decisions. He had a big laugh and a bigger heart. He was my mentor before being a mentor was a thing, and he was very generous with his experience and knowledge of matters that came before the commission. I know for certain I would not be here right now if it weren't for the support of Paul Harrington. I hope his wife Judy and his daughters Bridget and Molly know how much we all respected and enjoyed working with Paul. He will be missed. Thank you, Mr. Chairman.
Thank you, Commissioner. With that, we will begin the meeting with approval of the meeting minutes from our last meeting last week on June 3rd, 2020. The vote begins with Commissioner Richard.
I vote aye.
Commissioner O'Donnell.
Aye.
Commissioner Linton.
Aye.
And Commissioner Herman.
Aye.
Thank you. I vote aye. The minutes are approved. Mr. Secretary, the consent agenda.
Thank you, Mr. Chairman. At the outset today, item number 6 on today's administrative agenda will be deferred to next week's administrative meeting on June 17, 2020. There are 3 items on today's consent agenda. Item number 1 is the application of Hospital Energy LLC for a license to supply electricity or electric generation services in the state of Maryland. And item number 2 is an application for Hospital Energy LLC for a license to supply natural gas or natural gas supply services in the state of Maryland. And finally, item number 3 is the request of FC Stone LLC to cancel its electricity broker license.
Thank you. Do commissioners have questions on any of these items? Seeing none, I will move that with respect to items 1 and 2, that we grant Hospital Energy LLC a license to operate as a natural gas supplier in the state of Maryland with respect to item number 2, and as an electric supplier in the state of Maryland with respect to item number 1, limited to broker services for the customer classes and service territories applied for and recommended by staff. That we cancel the electricity and natural gas supplier license of Hospital Energy Services LLC. That we direct Hospital Energy LLC to file notice with the commission within 30 days of any changes to the information in the application. And that we inform the company that the existing bond of Hospital Energy Services LLC may be immediately canceled upon grant of the license for Hospital Energy LLC. With respect to item number 3, I move that we approve the cancellation of the request to cancel the electricity broker license. The vote begins with Commissioner Richard.
I vote aye.
Commissioner O'Donnell.
Aye.
Commissioner Linton.
Aye.
And Commissioner Herman.
Aye.
I vote aye. The motions are approved.
Mr. Chairman, item number 4 on today's administrative agenda is the application of CBRE Inc. to supply electricity or electric generation services in Maryland. On this item for staff, we have Catherine Mackerlane and Paige Shaw, and for the company, Andrew Schulte.
Thank you. Good morning, Ms. Shaw.
Chairman, and on behalf of staff.
The following item is an application made by CBRE Inc. to be an electricity supplier in Maryland. While the application was filed on January 10, 2020, the company began operating as an electricity broker in Maryland on January 15, 2020, despite the license not being approved. CBRE currently serves one Maryland electricity customer representing 8 Maryland electricity accounts. As energy procurement evolved as a part of CBRE's facilities management services, the company was unsure as to whether its activities required a license, but decided to file an application for a license out of an abundance of caution. However, the company has not received any revenue from energy brokering in Maryland. As CBRE has yet to begin receiving revenue for brokering, staff recommends the company be required to pay a civil penalty in the amount of $100. Staff recommends that the Commission grant the company a license to operate as an electricity supplier in Maryland, limited to electricity broker services to non-residential customers. Staff also recommends that the Commission issue a civil penalty to the company in the amount of $100. Finally, staff recommends the Commission direct the company to notify the Commission within 30 days of any changes to the information upon which the Commission relied in granting this license.
Thank you, Ms. Shaw. Counsel for CBRE.
Thank you, Mr. Chairman, and good morning, Mr. Chairman and Commissioners. My name is Andrew Schulte. I'm with the law firm Pulcinelli PC on behalf of the applicant. And I appreciate the opportunity to comment on staff's recommendation regarding CBRE's application for an electric broker license. I want to thank staff for their efforts reviewing the application and producing a recommendation that the Commission grant CBRE a license. Staff also recommended a $100 fine, and while CBRE appreciates the nominal nature of that fine, we do contest any implication of wrongdoing that accompanies the fine, as it may have an impact beyond the nominal dollar amount. For example, Maryland's own application form for a broker license requires the reporting of any reprimands or fines against the applicant or an affiliate, and requires that that information be updated if there are any new, quote, reprimands or fines in the future. And other states have similar requirements, so there could be a somewhat significant regulatory impact or compliance impact with the fine. CBRE does not believe its actions warrant a penalty. The impetus for the fine is the belief that CBRE operated with as an electric broker without a license beginning on January 15th of this year. However, CBRE is not a traditional energy broker. CBRE is really a facilities manager that oversees the procurement of a wide variety of products and services for buildings that are owned by its clients, such as janitorial, security, maintenance, etc. So CBRE's energy procurement activities evolved organically as part of its broad facilities management services for existing clients. And importantly, CBRE has never been paid for its energy procurement services. Historically, its identification of cost-effective energy suppliers for its clients was simply a part of its broad facilities management activities and contracts. Recently, however, a client with multiple facilities in Maryland requested that CBRE include an energy procurement fee in the client's energy supply contracts in order to better allocate the cost among its facilities, since it has 8 facilities across the state. This proposed change in fee structure is what triggered the electric broker application. And while the change in fee structure was intended to occur on January 15th of this year, the fact remains that CBRE has still not received any revenues under the fee structure because it does not yet have an electric broker license from the Commission. Accordingly, the one thing that triggered the application has not gone into effect in any real sense. And staff recognize that, and we appreciate that. In addition to not receiving any fees, CBRE has not behaved like an electric broker in any other traditional sense. CBRE has not solicited energy procurement customers, and it has not held itself out as an energy broker to the general public. CBRE filed its application out of an abundance of caution within a reasonable time of learning that its fee structure may trigger the requirement for a license. Accordingly, CBRE does not believe it violated the requirements of this commission's regulations and respectfully requests that the commission order granting the license reflects that. And with that, I'm happy to take any questions from the commission.
Thank you, counsel. I was just curious if our staff counsel had any response to counsel for CBRE's statement regarding the fine. Do commissioners have any questions of the parties?
Good morning, Chairman and Commissioners. This is Catherine Mackerline on behalf of Staff Counsel. Staff just recommends that the company be required to pay a civil penalty in the amount of $100. The Commission has issued similar penalties for similar supplier license applications in which the applicant operated in Maryland without the requisite license. With respect to the supplier operating without a license, the Commission directed the company to pay a penalty in the amount of the assessment it would have paid during the period it operated without a license in Maryland, or $100, whichever is larger. CBRE has been operating since January 15th, and they haven't received any revenue. That is why staff is recommending the $100 civil penalty.
Thank you, Ms. Mackerline. Commissioner O'Donnell.
Thank you, Mr. Chairman. Mr. Schultes, does the company operate in other states?
Yes, it does. It operates in, I don't have the full list in front of me, but I think it's approximately 8 other states. They're all competitive retail states that have similar electric broker definitions, and their services in those states arose organically like they did here as part of a broad facilities management platform.
And is CBRE licensed in those states to operate as a broker?
Yes.
What makes CBR think they might not have to be licensed in Maryland? What was the basis for that thought process? I don't get it.
Well, the definitions for broker are a little bit different in each state, and so we weren't sure if it would be triggered in our case. Having said that, we recognize that it likely is triggered, and we submit to the Commission's regulation and have no. We don't contest its application at this point.
Yeah, our staff evaluates technical competence and managerial competence in the energy field when they do the evaluation of these applications. And they say that you have a broad array of technical competence and managerial experience in the energy field, and yet the notion that you think you might not have to be a licensed broker in the state of Maryland to offer these services, it's hard for me to process that both of those could be true simultaneously. So my thinking is that this de minimis penalty at least strikes out the marker that the company should have known better. My thoughts. Thank you, Mr. Chairman.
Commissioner Linton.
Thank you, Mr. Chairman. Good morning. I had a question for Mr. Schulte. For CBRE's facilities operations management function, what is your role in managing the utility accounts for the buildings that you operate? Are you considered the customer to the utility company, or are you just paying the bill on behalf of the building owner?
Well, as part of our fiduciary duty to our clients, we review ways to save them money on their supplies and services for operating their facilities. And as part of that, we looked at their energy cost and identified the potential to save money by reviewing the market of energy suppliers and helping them select an energy supplier that would be most appropriate for their facilities. And
Okay. I'm sorry. So the owners of the building provided you, or regularly provide you, with a copy of their utility bill, or you have access to that energy information from the utility company.
yes, that is my understanding.
Okay, so CBRE's name is not on the utility bill.
No, sir.
Okay. And as part of your review, have you actually found a licensed supplier that provides energy at a different rate than the utility company?
That's my understanding, and I apologize. I don't have all the details of which energy supplier is supplying the facilities currently.
Right now, I wouldn't want you to say that. I just curious if you actually did that particular work. So you're saying that you have, that CBRE has in fact helped the owners of the building find a supplier.
Yes.
Okay. All right. Thank you. Thank you, Mr. Chairman.
Thank you. At this time, I'll call a vote. What I'm planning to do is bifurcate the vote. First, we'll discuss the license and then the penalty. So on the first vote, I move that we grant the company a license to operate as an electricity supplier in Maryland, limited to broker services for the customer classes and service territories applied for and as recommended by staff. And that we direct the company to file notice with the commission within 30 days of any changes to the information in the application. Vote begins with Commissioner Richard.
Mr. Chairman, I got a question on the motion.
Yes, Commissioner O'Donnell.
So, Mr. Chairman, if we're going to bifurcate this question, my vote on this first separated question may be different depending on what happens on the second part.
Oh, yes.
So I need to understand process-wise why we're separating the question. Because I may vote, my vote on the first part of this question may be affected by the bifurcation. So I need to understand why we're doing it.
I feel that two votes are appropriate. I believe this is two separate issues. One, whether to fine the company. Second, and apart, is whether to grant the company a license to operate as an electricity broker supplier.
Understood. But if the commission is not going to fine the company for operating as a broker, as they obviously, in response to Commissioner Linton, have offered services without a license, I may vote not to supply their license if we're not going to sanction them and let them violate our requirements without penalty.
Commissioner O'Donnell, would it address your concern if I call the second vote first?
Yes, sir, it would.
Let me do that. With regard to CBRE Incorporated, with regard to the question of the penalty, the motion is to direct the company to pay a civil penalty to the commission in the amount of $100. The vote begins with Commissioner Richard.
I vote no.
Commissioner O'Donnell.
Aye.
Commissioner Linton.
Aye.
Commissioner Herman.
I vote aye.
I vote aye. The motion is approved. The fine is assessed. With respect to the second vote, that we grant the company a license to operate as an electricity supplier in Maryland, limited to broker services for the customer classes and service territories applied for and recommended by staff, and direct the company to file notice with the commission within 30 days of any changes to the information in the application. The vote begins with Commissioner Richard.
Vote aye.
Commissioner O'Donnell.
Aye.
Commissioner Linton.
Aye.
Commissioner Herman.
Aye.
And I vote aye. The motion is approved unanimously on the second vote. Thank you.
Mr. Chairman, item number 5 on the administrative agenda consists of tariff revisions from Southern Maryland Electric Cooperative concerning its small generator interconnection standards. Item from staff, we have Lloyd Spivak, McAuliffe, and DeAndre Wilson. Company, Mark McDougall, Herb Regal, and Eugene Bradford.
Thank you. Good morning. Just a reminder to all to please mute your microphones unless you are actively speaking. We'll begin with staff.
Good morning, Mr. Chairman and Commissioners. Drew McAuliffe on behalf of staff. On May 1st, 2020, Southern Maryland Electric Cooperative filed proposed revisions to its rider SGIC, Small Generator Interconnection Standards, including renaming it Rider GIS, generator interconnection standards. This revision includes tariff language revisions as well as revisions to the rates applied to the various levels of interconnection. This filing reflects the approved changes made to COMAR 2050-0202 and COMAR 2050-09 approved by Rulemaking 68. RM 68 allowed utilities to derive their own level 2, 3, and 4 interconnections, while level 1 interconnection requests have no charge. SMECO is proposing a pre-application fee of $220 for a customer who requests a pre-application. SMECO is also proposing a $260 fee for level 2 and 3 interconnections and a $350 fee for level 4 interconnections. The interconnection fees are lower for all interconnection levels except for some level 2 interconnections, specifically those with nameplate capacity of 210 kilowatts and lower. Staff has also reviewed SMECO's updated tariff language, which complies with COMAR requirements. Staff recommends that the Commission accept the filing the proposed tariff revisions effective June 10th, 2020. Thank you.
Thank you, Mr. McAuliffe. Counsel for Southern Maryland Electric Cooperative.
Good morning, Mr. Chairman, Commissioners. This is Mark McDougall on behalf of Southern Maryland Electric Cooperative. With me today are Eugene Bradford, SMECO's Vice President of Rates and Energy Procurement, and Herb Regal of SMECO's Engineering Department. We have nothing to add to staff's comments and are here to answer any questions that the Commission might have.
Thank you. Do commissioners have any questions of the utility or staff? Commissioner Richard.
Yeah, McAuliffe, have you heard from the solar industry? I mean, are they okay with this tariff application? To your knowledge,
We have not. SMECO also is not part of the community solar program we currently have right now in Maryland, so that is not an issue in SMECO service territory. For, say, residential customers that are interested in net metering, increasing at RM 68 increased the level 1 interconnection from 10 kilowatts to 20. So we believe that should cover, I'm not aware of many residential customers with a solar facility of 20 kilowatts or more. So they would have no interconnection fee. So I have not heard from the solar industry, but I think this is pretty fair to the solar industry.
okay. Yeah, I was just concerned that there is a group in here that will be paying a higher connection fee, which seems to be contrary to the direction we should be going as a state, given our increased RPS requirement. But and this notice has been out there. It's presumably the solar industry has seen this tariff request.
Yes, I believe so. So again, community solar pilot isn't applicable in SMECO, but just to give you some numbers, the average size for those facilities are usually around 1.4 megawatts to 1.7 in our other service territories. So if a solar facility of that size was built in SMECO service territory, the fee would be lower. Again, if they're around that 20 kilowatt to about 200 kilowatt, the fee would be higher than was previously charged. Now, what customers would be building a solar facility of that size, I can't exactly say. Maybe a large warehouse of sorts. Maybe if for example, a Walmart tried to put a solar facility on a roof, they may fall into that category. Excuse me, but again, we think this is pretty fair to the solar community, and I have not had any feedback from them.
Okay, thank you.
Commissioner O'Donnell.
Mr. Chairman, Mr. McAuliffe, does technical staff agree with the cooperative's assertion that there's no need to restate the time limitations on their responses for applications or pre-application?
Yes, so staff did look into that. The other utilities, for example, do not list the response times in their tariff. So we did, broach that with the company. The tariff page does reference the COMAR section that is listed in, and it is clearly described in COMAR. So we felt that, and it can get a little confusing with some of the dates if you read through COMAR. If there's issues, the applicant has to send information back to the cooperative, to whichever utility, and then the utility has a certain number of days to review that. And it can get a little confusing if we were to put it in the tariff page. The only response time that was straightforward was the pre-application. The utility has to provide that within 20 days of the fee being paid. But we thought it could get a little confusing to put that in there. And again, COMAR does list that pretty directly, and SMECO's tariff does reference the COMAR section where applicants could find that information easily.
Fair enough. And what exactly does the pre-application buy you for the extra fee? What happens during that pre-application period?
I would let SMECO address that, but I think it just gives a general, A-OK to the applicant that there's enough capacity on the system to support what they're looking to interconnect.
Commissioner O'Donnell, I'd like to ask that Herb Regal answer that question.
Good morning, commissioners. Basically, I would refer to the pre-application fee as looking at a concept project where a developer may have limited information and may just provide a proposed system size and maybe a crossroads intersection location. And they're basically just looking as to whether or not there are any obvious constraints within that area to verify the type of distribution conductors and the capacity that appears to be available. So it's kind of like a preliminary concept plan, just looking for some information before they dive too deep into their proposed projects. Thank you.
And that is completely optional on the part of the applicant, right? There's no requirement to pay a pre-application fee or file a pre-application.
That's correct, Commissioner O'Donnell. And actually, I would also offer up that a pre-application is fairly rare. We don't anticipate seeing very many of them.
Very good. Thank you, Mr. Chairman.
Thank you. Seeing no additional questions from commissioners, I would move that we accept the tariff revisions for filing and direct the utility to file clean copies of tariff revisions with an effective date of June 10th, 2020. The vote begins with Commissioner Richard.
Vote aye.
Commissioner O'Donnell.
Aye.
Commissioner Linton.
Aye.
And Commissioner Herman.
Aye.
Vote aye. The motion is approved.
Mr. Chairman, item number 7 on today's administrative agenda is the application of Dan's Mountain Wind Force LLC for approval to construct a generation station pursuant to Section 7207.1 of the Public Utilities Article. On this item for staff, we have Kenneth Albert, Michael Zhang, DeAndre Wilson. We also have Darlene Park, McLeod, Bill Park of the Allegheny Neighbors and Citizens for Homeowners Rights Limited. For the company, we have Christopher Gunderson and Dave Friend. For PPRP, Sean Seaman and Sandra McLemore. And finally for OPC, Patrick O'Loughlin, as well as Bill Fields.
Thank you. We'll begin with staff.
Good morning, Chairman, Commissioners. Michael Jang on behalf of staff. This item relates to Dan's Mountains Wind Force LLC's application for approval to construct a generation station under PUA Section 7-207.1. The application was filed on January 14, 2020 for a Type 3 generation station not exceeding 70 megawatts in Frostburg, Maryland, powered by wind energy. The expected installation date is December 31st, 2021. The company had previously requested to approval to construct a similar project in 2008 and had previously obtained commission approval to construct a variation of the previous proposed project on March 12, 2009. However, the company later decided not to construct the project due to difficulties the company experienced when attempting to obtain its zoning variance from Allegheny County. In 2016, the company filed for a CPCN application for a variation of the project under case number 9413. The CPCN application in case number 9413 was denied in 2017. However, two factors distinguish the situation here from the situation faced by a commission in connection with Dan's Mountain's previous CPCN application. First, during the case number 9413, the county determined that the project violated zoning laws. And secondly, during the CPCN proceeding, the county was also opposed to the project. However, at this time, the company has now obtained zoning approval from Allegheny County and has also received support of the project from Allegheny Board of County Commissioners and is thus applying for approval to construct the project under PUA Section 7-207.1. The company has shown that the project meets the requirements for exemption under PUA Section 7-207.1. The facility will not exceed 70 megawatts, and the company has submitted an interconnection service agreement with both the Potomac Edison Company and PJM. The company has also provided notice of its intent to construct a facility to the required recipients as required by the notification letter sent by the Commission dated January 29, 2020. Furthermore, a public hearing was held on May 20th, 2020. Staff has also reviewed the letters received from the public in regards to this project. Staff reviewed the application and concluded that Dan's Mountain has met the requirements set forth in Section 7-207.1. Staff recommends that Commission approve the application and direct the applicant to notify the Commission in writing 2 weeks before first export of electricity.
Thank you, Mr. Jang. We'll next turn to Counsel for Anchor, Allegheny Neighbors and Citizens for Homeowners Rights Limited.
Yeah, thank you, Mr. Chairman and members of the commission. You can hear me okay?
We can.
Thank you very much. I appreciate this opportunity to appear on behalf of Anchor. For the record, my name is Chip McLeod with McLeod Law Group. We submitted a letter to the commission dated May 15th, 2020 that I just want to confirm is in the record for this proceeding. And I want to use that comment letter as an outline for my comments this morning. On behalf of Anchor, the first comment I'd like to make is the recommendation to the commission that this application be denied on its face. And let me explain why. Under the doctrines of res judicata and collateral estoppel, this is really the third bite at the apple for this applicant with this particular project. As you heard from staff, and I'd like to elaborate on staff's report, they talked to you a little bit about the history, but I believe there's a lot more detail and color history that's important for the commission. I recognize, I believe, 2 members of this commission may have been sitting, I believe, when one of these prior decisions on this particular project was made. And I know for some of the commissioners, this may be new. So let me give you a little history. This project did in fact receive a CPCN exemption some time ago. The applicant actually terminated that exemption on their own volition, and I'll explain why. While they had a CPCN exemption and were awaiting Allegheny County approval, local zoning approval, they applied for a CPCN application at the same time. We were representing Anchor at that time, and it was brought up and questioned how an applicant could have both pending at the same time, a CPCN exemption that was continuing on some extensions because the project had never been built pursuant to that exemption, and at the same time was pursuing a CPCN application. And during that process, PULJ Judge Romine correctly said to the applicant, look, you need to make a choice here. Either we're proceeding with this CPCN application, or you have to do something about this exemption that's hanging out there. And the applicant voluntarily withdrew that prior exemption and went forward with a straightforward CPCN application. That application was denied. That denial was upheld by this commission, and that denial of the CPCN application was appealed to the Circuit Court of Baltimore City and was upheld. So you have a denial of this project on a straight CPCN application, denied and upheld in the courts. Now they come back for another CPCN exemption. Under those doctrines of res judicata and collateral estoppel, the residents of that mountain have not had any repose They have no peaceful enjoyment of their property on that mountain, having to look over their shoulder when the next application for the same project might appear. Now, let me talk about the project. From the application, the current application, we don't know how many windmills we're talking about, and we don't know how big these windmills are. So it's a little confusing to us on how this has even gotten this far on an application that to us, and for the record, we will say we believe is incomplete, which is another reason for the denial. And let me just quote, if I could, when the commission approved the denial of the CPCN application for this project, this was one of the comments made. Benefits that may accrue to the public at large by construction of the project do not justify or offset subjecting the local community to the adverse impacts that will result from the project's construction and operation. That's a prior CPCN denial decision. Now, the applicant, the current applicant in this most recent application says in their application, we are applying for a CPCN exemption again. And they say nothing new is likely to precipitate from this whole process. In fact, the applicant didn't even want a public hearing. They said, hey, nothing's changed. Well, the fact that nothing's changed is why this application should be denied. Because here's some things that were supposed to have changed if this project were to have been built. There is a emergency communications tower on this mountain. During the first CPCN process, that tower hadn't been built. It was being talked about. But this is a 911 emergency communications tower, Maryland First. It was going to be 230 feet. I think it was built at 300 feet. That tower is now on the mountain operating emergency communications for the region. Nothing in this application speaks to the impact of these windmills on that emergency communications tower. And yet, in Judge Romine's prior review of this project, one of the conditions she felt was important related to that emergency communications tower, she put in her decision and wanted to impose that on the applicant, who then said, you know, that's not workable. But you all, I think, have a serious issue just on that point, that you have an applicant coming back to you with the same project that's been previously denied. They've done nothing else different to address the local impacts on neighbors and noise and what have you. And in the meantime, you have a brand new emergency communications tower, and we have no study, no data, nothing to tell us there's not going to be any impact on that tower. Another change in circumstances is since the prior applications, you have more homes that have been built on Dan's Mountain. So you presumably you have more people that are going to be impacted. Okay. So I've talked about why we believe the application on its face should be denied on principles of res judicata and collateral estoppel. Again, the people of Dan's Mountain deserve repose. If the commission is inclined to allow this to move forward, we think it's absolutely imperative that it looks hard at this project. It's been presented that what's different is now the county government supports the project and there's local zoning approval, so everything's hunky-dory. Well, the residents of the mountain and the members of Anchor, their concerns have in no way been addressed by anything that's happening at the county government. And let me say this about the supposed local government support and local zoning approval. That decision by the local Board of Zoning Appeals has been appealed, and that appeal is pending in the Circuit Court for Allegheny County. So you do not have a final adjudication on whether, in fact, this particular project as proposed has been approved or the approval of the county zoning is in fact final, because it's on appeal right now. I believe the Circuit Court case or hearing on that is in August. I could be corrected, but I believe that hearing is in August. But under the Public Utilities article, section 2-113, the commission is directed, it says the commission shall supervise and regulate public service companies. And it goes on to say they shall do so without unjust discrimination. And let me say that the people on Dan's Mountain, the members of Anchor, feel discriminated against at this project, twice denied, or once pulled, once denied, is back again with no changes whatsoever. Section 2113 goes on to say, in supervising and regulating public service companies, the commission shall consider public safety, the economy of the state, the conservation of natural resources, and the preservation of environmental quality. I think if you just approve this application today as introduced and based on these comments, you will not have fulfilled that part of your charge under the state code. So in summarizing this, we think the decisions in cases number 9164 and case 9413 have preclusive effect on this instant application. And it really is unfair for the people of Allegheny County or on the mountain to have to continue to wonder when this project is going to reappear. And a couple more comments, Mr. Chairman and members of the commission. Again, if you're inclined to consider to let this project move forward, I want to point out some of the key issues that have not been addressed and were a major issue during the first two go-arounds. There's no mention in the application about the visual impacts to the surrounding properties. There's no mention about noise and shadow flicker. They don't want to address that, and yet those were very important during the hearing on the prior CPCN application. As I mentioned, more homes have been built in the vicinity. And I mentioned the potential impact on emergency services, which you cannot take lightly. You have a brand new 300-foot emergency communication tower on that mountain. And nothing in this application reassures the general public or frankly, the emergency service providers that there won't be any impact. And then I do want to speak about the public hearing and the comment letters that were received, because we looked at the staff report. You know, if this is a popularity contest and you got to count letters and what have you, just for the record, we want to set this right. By our count, there were 195 submissions opposed to the project, and there were 132 letters received that indicated support. However, of those 132 letters, 66 had either no addresses or no names. So if you boil those out.
Mr. McLeod, I'll interrupt you there. This is not a popularity contest. And
well, I'm sorry, Mr. Chair, but I just want to point out the staff report, I think, mentions a fewer numbers of letters received. So I just want to mention that to the members. And then I would also ask if it's appropriate or not, because we think it's important that the record in case number 9164 and case number 9413 be part of this record, because these are essentially the same project. Although, let me say this, we think they're the same project, but we don't know for sure how many towers and how big they are, but it's generally the same project.
We'll hear from counsel from Dan's Mountain in a minute and address that point. Mr. McLeod, do you have additional?
No, I'm sorry, Mr. Chairman. I was going to say I was finished. So thank you.
Thank you. Just want to make sure I have all the parties here correctly. So we'll move next to Office of People's Counsel.
Good morning, Your Honor. Patrick O'Laughlin for Office of People's Counsel. We have nothing additional to add to our filing of Monday, but I am available for any questions.
Thank you, Mr. O'Laughlin. Any comments from the power plant research project? Mr. O'Laughlin, if you could, thank you.
Good morning, Commissioners. As noted in the letter filed with the Commission, PPRP is taking no position in this matter. We are available to assist the Commission in any technical information that you may have.
Thank you, Ms. Mack. I believe that we've heard from all the parties here, except for Counsel for Dan's Mountain. So, Mr. Gunderson.
Thank you, Your Honor. Chris Gunnarsson on behalf of Dan's Mountain Wind Force. I'm also joined today by a representative of Dan's Mountain, Mr. David Friend, who is also available to answer any questions regarding the project. I'll just briefly address some of the comments that Councilor Anker just made, particularly as to the doctrines of res judicata or collateral estoppel. And then I'll turn it over to Mr. Friend to address anything that I missed, quite frankly. So first off, Your Honor and Commissioners, in a general sense, the doctrines of res judicata or collateral estoppel preclude a litigant from obtaining the same relief from a court that was previously denied by the court or another court under the same rules of law and the same facts. So the litigant must be pursuing a previously denied claim or relitigating a case that was previously adjudicated adversely. As a result, these doctrines apply in situations where you have the same claim, same parties, and the issues are resolved under the same statutory framework. As to the application that is before you today, Dan's Mountain has never been denied a CPCN exemption for this project. In fact, a prior version of this project was granted a CPCN exemption. The Commission's denial of a CPCN in 2017 for a similar version of this project is not the same claim and does not involve the same legal standards as an exemption application. A CPCN involves entirely different statutory framework than what is to be applied today. And in the case of this project, when the Commission was reviewing whether to grant a CPCN to the project back in 2016, the company was asking the Commission to preempt an adverse local zoning decision that was in place at that time. And that is not the claim, and that is not the relief that the company is seeking today. Today, we are asking the Commission to issue an exemption under 7207.1 because the project meets the defined criteria of an exempt project. And in which case, the project would then be fully governed by the Allegheny County local zoning laws and subject to the local zoning decision that approved the project. So because we're seeking entirely different relief based on different statutory standards, there's no collateral estoppel or res judicata issue for the Commission to resolve in this matter. And just to briefly address Judge Romine's decision in the CPCN case regarding the relinquishment or expiration of the prior exemption. I think there's other points there that are important here. At the time that Dan's Mountain filed for an application for a CPCN back in 2016, yes, the company still had in place a CPCN exemption. That exemption would have expired or set to expire at the end of 2016. Allegheny County actually filed a motion to dismiss the CPCN application in which the county argued that the Commission could not grant a CPCN to an exempt project because granting the exemption vested the county with exclusive regulatory authority through the county zoning process. What Judge Romine ruled was that while the project qualified for an exemption, and while an exempt project could seek a CPCN, the Commission's authority to preempt local zoning laws, because again at that time there was an adverse local zoning decision. So the Commission's authority to preempt that decision and preempt local zoning laws would have been limited if the exemption remained in place. So Judge Romine denied the motion to dismiss and also denied a subsequent motion to stay the application with the condition that Dan's Mountain clarify whether it was going to continue to seek renewal of the CPCN exemption. A few days later, Dan's Mountain confirmed in writing that it would not seek an extension of the prior exemption, therefore it expired. And as a result of that process and that decision, there's no collateral estoppel issue because Judge Romine's order did not make a determination that the project was no longer exempt from the CPCN requirement. In fact, she found the opposite. She found that it wasn't exempt or would qualify as an exempt project. So simply put, there was no adverse ruling against Dan's Mountain at all on the issue of the CPCN exemption in that So for all of those reasons, we submit that the principles of res judicata or collateral estoppel simply don't apply in this proceeding. And then, so I'll briefly touch on, Counsel for Anchor mentioned a series of issues or conditions that had been addressed in the prior CPCN proceeding. All of the specific issues or conditions related to the project, those would now be the subject of the local zoning authority, and they were, many of them or all of them were addressed in the local zoning board's review of the project and approval of the project. To the extent there continues to be concerns by members of the public related to the project, under the exemption process, those would then be the purview of the local authorities, the local zoning board, the county commissioners, et cetera, to address to the extent that they feel it should be addressed. I think I've covered everything that I can on Counsel for Anchor's comments. I'll turn it over to Mr. Friend if he has anything else to add.
I think the one thing I wanted to address in particular relates to
Friend.
Oh, can you hear me?
Just state your name, title, and affiliation, please.
Sure. Dave Friend, I'm the managing partner of Laurel Renewable Partners. We are the sole owner of Dan's Mountain Wind Force LLC and the applicant.
Thank you. Your comments?
Great. I just wanted to address for a moment a couple of the things that Counsel for Anchor mentioned, particularly the communication towers. He implied that there was no effort made or resolution of some concerns that were addressed early on regarding communication towers. First, I want to point out that there is a robust set of condition or regulations in Allegheny County Code regarding wind energy generation, one of which has to do with electromagnetic interference. It specifically requires the applicant for zoning to obtain an electromagnetic interference analysis, which prior to this, I don't think anyone had ever done because no one else has that requirement. We did it actually twice for two different iterations. The ultimate one for the 17 turbine layout was 377 pages. It details every tower on that mountain, every microwave beam path, radio, TV, any of the others. It specifically addressed the 330-foot communication tower that was being erected at that time by the state of Maryland. And I might add that the county did not object in any way in the proceedings, either before the Board of Zoning Appeals or the CPCN process. They didn't produce any evidence or anyone saying that it would work. Some of the opponents did, of course, but the one person that testified, I think conclusively before the PSC was a gentleman from the state police. He's the Major Hassanai, who's in charge of the communication systems in Maryland. He testified very eloquently that he wears a badge and a uniform and takes calls, and that if he were concerned at all about the potential interference on 911 systems, that he would be in fact saying something different up there. There was an agreement at that time to put in place a memorandum of understanding, and we're still willing to do that between us and the police, but it's a county process at this point, as I understand it. That 377-page document went out to 150 different counterparties. There were only 7 comments, and all of them were resolved through communication. So I feel very comfortable that we're not going to interfere with any communications. I think every one of the other things was brought up, I believe, are addressed satisfactorily in the code in Allegheny County. They've been subject to a lot of discussion and resolution there. And although it took a long time through the courts, it was finally decided that the project met the requirements of the code. And I might add that Anchor was very much, maybe not as an entity, but as individuals, were very much involved in the process of developing those code changes that were put in place after the original CPCN exemption was obtained, and the project was just 3 or 4 months away from construction when they changed the code and essentially zoned out the 29 turbine layout that was then proposed.
Great. Thank you, Mr. Friend. Obviously, this is a case that stretches back more than a decade. There's been many changes along the way, including the composition of the county commissioners, this commission, the Board of Zoning. But one thing that hasn't changed are some of the legal doctrines. So I'm glad we've touched on both collateral estoppel and res judicata. The Court of Appeals of the state has long held that res judicata and the principles contained therein do apply to administrative and quasi-judicial determinations here. As a general rule, I'm looking at some of these cases that have been cited for years. There has to be a substantial change to warrant a second review by a commission or some type of administrative tribunal, which would include the PSC. Taking a look at the application that we now have before us, this is being directed to Mr. Gunderson. The project, is it the same project from 2016, or is your argument that we're essentially seeking a different approval today under a different legal theory?
Yes, Your Honor. I guess it's twofold. One, it is a different approval under a different legal theory. And two, there are some differences between the posture of the project now as compared to the posture of the project in 2016. But the most important is that we are seeking approval here under a different statutory construct. And on that point, I did do a little bit of research last night, and there's a Court of Appeals case. It's captioned CICALA, C-I-C-A-L-A versus Disability Review Board. And it's found at 288 Maryland 254. And in that case, the Court of Appeals held that even when the underlying issues are the same, the principles of res judicata do not apply to a subsequent administrative proceeding when a prior administrative proceeding involved the application of a different statutory standard. So I think that is similar here. In that case, it was a review of a police officer's, the nature of a police officer's injuries, and the court was asked to decide whether res judicata applied to a workers' compensation commission decision regarding the nature of those injuries in a subsequent proceeding involving a disability review board. And the court found there, in that case, that because the two sets of statutory standards were different, that even, I'll just read from the case. It says, because the Workers' Compensation Act and the county pension plan have different coverage, funding sources, procedures, and standards, the issues presented to the commission and the board, although they both involve the question whether the policeman's injury was related to his employment, were not identical. The principles of res judicata do not apply. I think that that same reasoning would hold true here. The prior application for a CPCN was regulated by an entirely different statute, different standards of review, different factors that the commission considers as compared to the application for a CPCN exemption that's before you today. Therefore, the principles of res judicata would not apply.
Mr. Gunderson, that case that you just cited, 288 Maryland 254, what year was that?
1980.
1980, thank you. With respect to the physical project, are there any substantial changes to the project since 2016?
I'll let Mr. Friend address that with respect to physical changes. But I think there are the two changes or two differences in the posture of the case that were weighed heavily during the CPCN process that are different now are, were touched on briefly by staff's comments. Number one, as the commission knows, one of the first criteria the commission reviews in a CPCN is the recommendation of the local governing authorities. And during the 2016 CPCN, Allegheny County was protecting its local zoning authority, and the commission weighed that position heavily in its decision on the CPCN application. Now the project enjoys strong support from the county commissioners. As attached to the applications as Exhibit C is a letter of support from the county that attached the application for the exemption. And then secondly, at the time that the CPCN was denied in 2017, as was mentioned, the county zoning board had ruled the project was not compliant with county zoning laws. And again, the commission in 2017 weighed that fact heavily. On the other hand, this time around, the project has now been approved by the county zoning board. So those are two very important and very distinct differences between the posture of the project back in 2016, 2017 as compared to now.
It's evident to this commissioner that the law has changed as well, in addition to all the composition of the bodies here. Counsel for Anchor mentioned that the zoning decision is now on appeal to a circuit court. I'm not sure what court, perhaps Allegheny County. Would it be premature for this commission to rule today absent a decision by the circuit court?
No, Your Honor. While the zoning board decision is on appeal, it has not been stayed. That order has not been stayed, to my knowledge. Therefore, I think it's perfectly ripe for this commission to make a decision on the application for an exemption. Also note that, as staff noted in its comments, the commission's approval of the exemption is still subject to the project being compliant with local zoning rules and regulations and laws. Therefore, to the extent the local zoning board decision gets overturned, we certainly do not expect to happen. The project would not be able to go forward without that approval.
Thank you, Mr. Gunderson. I may have more questions, but at this time, I'd like to yield to my colleagues to see if they have any questions to ask. I'll start with Commissioner O'Donnell.
Thank you, Mr. Chairman. Mr. Gunderson, isn't it true that the original denial by the Allegheny County Board of Zoning Appeals was challenged in the circuit court for this project? And the circuit court upheld that denial, and then it went the whole way to the Court of Appeals, and the Court of Appeals reversed the circuit court's upholding of the local Board of Zoning Appeals case. Isn't that so?
That's correct.
And the Court of Appeals remanded the Board of Zoning Appeals decision back to the circuit court for further remand to the Board of Zoning Appeals to correct the deficiencies that the original denial was issued under. Is that not correct? Is that correct?
That's correct.
So that's a big change in my mind, in that the Court of Appeals said the original local governing authority with regard to zoning appeals matters or variances erred in their original decision. To reverse that and send it back and say fix this is a huge change. And we're required statutorily at the commission to consider local governing authorities. We have preemptive citing authority, and which we jealously guard for good reason, I believe. But the reality is we do give due deference and consideration to those local matters, and that changed significantly. Is that not so?
I agree.
Okay, and notwithstanding the change in position of the Board of County Commissioners, who have had to deal with economic conditions like the closing of Luke Mill and other things in a very depressed part of our state, we're also required to consider economic impacts in our state, amongst many other considerations. And isn't that a significant change in that was considered in the first decision? Would you agree? So don't all those changes, when combined, kind of argue against the implementation of res judicata. These are big changes in circumstances and law, in my opinion, that would argue against implementing those principles.
I agree that the project is in a very much different posture than it was back then. Absolutely.
So I'm being a layperson and not a lawyer. I just wanted to check those thought processes because I think we're on pretty solid ground from a legal standpoint. I may have other ideas about this project, but from a legal standpoint, I think we're on pretty solid ground. Should we decide to issue this exemption?
Thank you, Commissioner O'Donnell. Do other commissioners have any questions for the parties?
Yes, Mr. Chairman, I do.
Commissioner Herman.
Thank you, Mr. Chairman. Mr. Gunderson or Mr. Friend, Mr. Gunderson stated in his review of the res judicata that we needed to have, for it to apply, you need the same rules of law and the same facts. So have the number of turbines for the project changed?
Dave, I can address that. We frankly don't know. We have zoning approval for up to 17 turbines. Okay. However, we don't know what brand or model of turbine we can use because we don't know when we can build the project and we don't know what turbines will be available. For instance, if I were to tell you that we've used the same machines that we proposed in earlier rounds, I would be completely unable to buy those at this time. It would be like asking me to buy a 2009 automobile brand new. Can't do it. They're not available. So what we propose to do is use the best available technology when we know we can move forward. And we don't know what that will be. It may result in some adaptation of the layout. It may result in a reduction of numbers of turbines. We just don't know. We'll make those all work, but they have to work within the boundaries of the zoning regulations.
So would your answer be the same for the setbacks and the layout then of these, of where the turbines would go?
The layout may change, but all within the setbacks that are required by the county.
Okay. And in 2017, I believe it was, when the commission upheld Judge Romine's denial of the CPCN, the commission found that the project would have an adverse impact on the aesthetics of the local communities on and around Dan's Mountain. So how has the project changed to address the aesthetics on the local community?
I think that the judge's debate in that case had to do with her perception that we didn't provide a rendering from one location in the Harwood subdivision. We obviously have the ability to do that, but until we know what machine and at what location, it's difficult to say that we've done it adequately. It's an open-ended issue at this point in time. However, that was, I think, done subsequently during that process so that we could see what it would look like. I might add that in that balancing test that Judge Romine went through, she, in my opinion, grossly underestimated the positive impacts to the community. She used words like minimal economic impact. Well, I'm here to tell you this will become the third largest property taxpayer in Allegheny County immediately when it's built. That's not insignificant. It's about $1 million average, about $1.2 million first year. You're talking about a community that lost its largest employer, the Luke Mill, January 31st of 2019. The impact from the COVID, we don't know what's happening there yet, but I can tell you that there's a giant impact there. The landowners immediately within the project area that are also participants in the project, they're fully supported. It's a dramatic positive impact to them. People at some distance to wind turbines can see them. Judge Romine's order, in my mind, and I'm not a lawyer, but she almost implied that if we couldn't make them disappear from view, that she would never be satisfied. I completely disagree with that.
Let me just stop you there because I'm not trying to relitigate the commission's decision, which upheld Judge Romine's order. What I'm looking at is the commission's order, not Judge Romine's order, but the commission's order upholding her order found that the project would have an adverse impact on the aesthetics and also some concerns with respect to noise and shadow flicker. So I'm trying to understand whether anything has changed that would address those issues.
Well, turbine technology continues to evolve in a positive way. They're getting more efficient and quieter, so that will be a positive impact there. And I might add that it will be well within the state standards for noise. I missed the other issue, I'm sorry.
The flicker, the noise and the flicker.
Flicker is determined strictly by the size and shape and location of the machines. Until I know which machine, I can't predict accurately what it will be. But when I know what turbine we're going to use, I can predict accurately what impact will be, how many minutes per day per year on any particular device, structure, wherever. Once we're there, we have the ability to predict that and work with any landowner that might be impacted to help minimize or restrict. For instance, if someone has a shadow coming across their garage for 18 minutes on a Tuesday in January, but they're at work at that point in time, there's no impact to them. So we have to look at each situation very carefully and work with those landowners if we think that there's a significant impact.
So I'd like to ask a couple of questions to the applicants and potentially to PPRP, that if the commission were to approve this project today, if residents had concerns with respect to noise and flicker, what agency, where would they go? Would they go to the zoning authority? Would they go somewhere to DNR with respect to noise? Those are questions, and I have a number of questions with respect to certain concerns that were raised by residents, So where would they go if the commission were to approve this today? Where would they go next so they have a place to take their concerns?
In my mind, they would go first to the company that's operating the project, second to any local zoning authority like Allegheny County, and third to any state agency that would have jurisdiction over that issue. For instance, if we were violating a noise standard, they would go to the state because that's where the standard resides.
Okay. And what about impact on, there was concern with respect to impact on their wells. Where would they go to address their concerns or to voice their concerns with respect to the impact?
That's covered by the code in Allegheny County. It requires us to post a bond and to test all wells within a mile of the proposed wind farm. By the way, I'd add that's a standard I've not seen anywhere else.
And what about decommissioning? Where would they go for that?
Decommissioning is as well covered by the code in Allegheny County and will be required to post a bond for that.
Okay. Mr. Chairman, I might have some more questions, but I think I've gone through a number of them.
Thank you, Commissioner. Do any other commissioners have questions?
Mr. Chairman, if no are ready to ask questions, I have a few others.
Please.
PPRP, if we have them, I don't see them. There we go, Ms. McElmore. So is PPRP give us a one-sentence submittal saying we're not going to take a position, but is PPRP satisfied that environmental impacts due to construction, such as impacts to the Savage River watershed, which I believe is on one side of this mountain, and the north branch of the Potomac River on the other side, is PPRP residing in the Department of Natural Resources satisfied that construction impacts will be adequately controlled?
Your Honor, as this is an issue under the exemption, we don't have a formal position in this case, but we did provide something in Dan's Mountain Wind. There are, as Mr. Friend said, the county is there as well as state agencies that would normally address this will be available, but we have not looked at it to determine if there would be any other, if we're satisfied or not.
Yeah, I mean, these are very sensitive watersheds. They obviously, we know that they're a very pristine part of our state. We want to make sure that there are no adverse impacts in the state. The state executive authority is kind of being ceded to the local executive authority to control this sort of stuff. Or am I reading that wrong?
Your Honor, there are certain state agencies that are involved in certain jurisdictional issues. For example, with groundwater, they work with the county, MDE does, and also with noise, I believe, as well. And also, DNR is there to deal with the natural resources issues. However, some of the enforcement authority to deal with everything, I don't believe is always there. But that would be a case-by-case question. And of course, we would be here to help the county and the commission address what would be the responsive agency for each of these issues.
Yeah, normally PPCM process, a lot of those things are taken care of conditionally and have a forced compliance at the state level, but that's not going to occur here, at least not in this process should we issue. Mr. Friend, let me follow up with you on that line of questioning. So I read the 164-page application and exhibits attached. There's discussion in there about operational cooperation with DNR, mortality of wildlife, et cetera, but that's after the project begins operating. Who is going to do for instance, the sedimentation control at the construction site during construction? You know, the silt fencing that's put up, the buffering and mitigation of that. Who will control that? Will that be strictly enforced by the local code enforcement authority, or who does that?
Well, prior to construction, we're required to have a stormwater management program in place. It has to be approved by the county, and I believe the DEP has a lot of oversight in that area as well. Post-construction, DEP monitors that, and the county, I believe, has a big impact as well on monitoring that to make sure that the stormwater fortifications and processes are in place and well taken care of. I think I'd point to the fact that there are other wind farms in Maryland and the process has worked.
Yeah, so, well, I'm not sure they all got a CPCN exemption. We're not discussing all those here. So let me just ask you this. You talked about before construction, you got to file a plan, and after construction, monitoring. How about during construction is really what I'm asking you. Who monitors that and enforces that? So if you have a gully washer that comes through the mountains up there, through those Allegheny Mountains, and the gully washer causes an extensive erosion problem due to your construction, who's going to be monitoring and enforcing that?
I believe DEP has the primary on that.
Who?
DEP, I believe.
DEP, Department of the Environment?
Yeah, sorry, I cross over state lines a lot, so some states use a different terminology. Yes.
Right. So you think the state would do that? The state would be on hand to enforce that?
That's my belief. I think the county also has a role, though, and I'm not sure how they interact.
You might be the wrong. Maybe PPRP's maybe the right person.
Might be true. I'd also like to look back on an earlier question that you posed, sir. One having to do with wildlife, and I understand PPRP's perspective here that they haven't evaluated the exemption application, but they did spend a lot of time with the CPCN application that we've looked back on a number of times in this discussion. And I believe at that time they were in concurrence that we had met those environmental regulations. We've worked with both DNR and U.S. Fish and Wildlife Service to meet all of the wildlife requirements, which is then backed up by the Allegheny County Zoning Code. So I think we've got that one covered pretty well as well.
Ms. McLemore, did you hear my question regarding enforcement during construction?
Your Commissioner, I'm sorry, you froze up a little bit there. Could you repeat it? Exactly.
So my question is, who is going to do the enforcement during the construction process? And I kind of posed it as a hypothetical. A gully washer comes through the Allegheny Mountains, creating a lot of runoff, and you have a big erosion problem at a construction site for one of these towers, and it starts having an impact on, say, the Savage River or the North Branch of the Potomac River. Who's going to do the enforcement during the construction process?
I believe it would be the county and Maryland Department of Environment working in coordination. However, I could provide you with more information in writing if there is anything else to address that, but I believe it would be the county and MDE.
Okay. All right, thank you, Mr. Chairman. That's all I have for now.
Mr. Chairman, this is Chip McLeod.
Yes. Did you want to respond to Commissioner O'Donnell?
Well, I just wanted to ask if there would be an opportunity to respond to some of the comments that are made. And I just want to make sure there's an opportunity to do that.
If you'd like, what comment would you like to, which commissioner's question?
Well, actually, it speaks to the applicant's counsel, some of their comments, and I have 3 points I'd like to make. First of all, the case cited by counsel for the applicant, I just want to point out, we think is an opposite. It involves 2 separate agencies. Here, we're talking about the same agency, the Public Service Commission. So if we're going to start citing cases to, convince the commission to make a decision right now, either if we're going to do that, I would expect we have opportunity to brief that. But I'll just say now, just glancing at that case, it seems an opposite because it involved 2 separate agencies, not a single agency. I also want to say, there seems to be a lot of emphasis on the prior CPCN that it was all about local zoning. And that's not the case. If you look at the decision in the CPCN that was denied, it was not just about the county input. It was a lot about the neighbor impact and noise and flicker. And in fact, let me just say, some of you may remember during the prior CPN case, my firm, I represented Allegheny County. And our job was to protect the county's interest from being preempted. When the decision was made to deny the CPCN exemption, and I read it because we were part of it there for the county, you actually read it, it was a lot less about the county's input than it was about the citizen input. So I just want to reiterate again, we're making it sound like just because now the county's on board, everything's hunky-dory. There is a host of issues that were litigated in the CPCN application that are on the record that are remaining unresolved just because now they're coming in under the exemption statute. And let me just say one more thing, if I could, Mr. Chair. When the commission adopted Judge Romine's decision denying the CPCN application, this is what they said. We are troubled that an applicant would utilize such a strategy for substantially the same project when no significant time had elapsed or conditions had changed. Notwithstanding this potential collateral estoppel issue, we will proceed to decide this case on the merits. So the commission itself was concerned about collateral estoppel when they did this, when they took the second bite at the apple, but they went ahead and decided on the merits, and on the merits, it was denied. Thank you, Mr. Chairman.
Thank you, counsel. As I stated at the outset, and hearing the arguments today, we've heard a number of arguments from both sides. We've reviewed many letters from folks in the county, in the city, in the Harwood subdivision. We heard from the chief public utility law judge a few weeks back after he spent the evening with citizens who provided public comment and input regarding the proposal that is currently before the commission today. If I look simply at PUA 7-2071, it does on its face favor the applicants. However, we did have an important discussion today on res judicata and collateral estoppel. And I had the ability to do some pull some of the seminal cases that I've been reviewing here. Looking at the Kent County Board of Education versus Bilbro case, 309 Maryland 47, it's clear that a mere change in legal theory applied to the same set of facts previously litigated will not in and of itself preclude a cause of res judicata. However, that said, there have been substantial elements of that have changed since we last saw this project in its iteration in case number 9413. And taking a look at the CICLA case versus Disability Review Board, while I agree with counsel for Anchor that that case involved two agencies, the Court of Appeals did determine that a determination under one statute is not binding when the same question arises under another statute. Here, obviously, we're still working within the PUA, but we have multiple elements at play. And the administrative law treatise that the Court of Appeals cites recognizes that that conclusion may still be sound and would not necessarily be res judicata when the same question arises under identical words of a different statute. I read that also to be within a different section of the statute. So based on what I've heard from the party today, I am comfortable that there has been material changes that would overcome any claim of res judicata, despite the very tortured history of this case and the pending litigation before the Supreme Court. I'm going to vote to grant the company's application for an exemption of a CPCN under Section 7-207.1. I'm going to call a vote at this time. I move that the Public Service Commission grant the company's application for an exemption of the requirements to obtain a CPCN pursuant to PUA Section 7-207.1 and direct the applicant to notify the Commission in writing 2 weeks before the first export of electricity. The vote begins with Commissioner Richard.
I vote aye.
Commissioner O'Donnell.
I vote aye.
Commissioner Linton.
Aye.
And Commissioner Herman.
I vote nay on the motion, Mr. Chairman. I would have asked for briefing on the res judicata issue and taken the matter under advisement. I'm not convinced that that legal principle doesn't apply. In my mind, there is insufficient evidence that the law hasn't, I know the law hasn't changed, but I don't see sufficient evidence the facts haven't changed. So I would have voted to explore this further and review briefs on the matter from the parties. Thank you.
Thank you, Commissioner. I vote aye on the motion. The motion carries by a vote of 4-1. Seeing no additional business before the Commission today, this meeting is adjourned.